We'll get to that in just a moment. For vertical agreements, following various reforms, the rules that we have now contained in Regulation 330 and the relevant guidelines, the guidelines on vertical restraints, also from 2010. So they basically establish that an agreement, a vertical agreement, will be lawful if the market share of the parties is 30% or less, and there are no hardcore restrictions. So Article 4 of the regulation contains a list of hardcore restrictions, which include, for instance, price maintenance and some territorial restrictions, which again we will discuss in this presentation. So that's basically the background to the current rules. So here I've included a reference from an OECD document talking about the challenges of the digital economy, referring to platform-based business models, multi-sided markets, network effects, economies of scale. Now, what we see from this brief description of the challenges, it seems that the focus is more on market power, the possibility of collusion, and the issues relating to disruptive innovation. But what about vertical agreements? Is there anything that we need to watch out for? So what I've done in this presentation is I look mainly at recent developments, because I think they give us an idea of what we might expect come 2022. Now, it is important to note that not that much has happened at the EU level. Enforcement has perhaps mainly taken place at the national level. And this means that since the extent to which vertical agreements are harmful is something that is up for debate, and there is no overall agreement on this, it means that there is a risk of uneven application. There may be some competition authorities that are more active than others, or that are harsher than others when looking at vertical restraints. Now, one important development, which is quite novel, and which I believe that Avantika is going to cover, is some investigations that have looked at most favored nation clauses. Now, since Avantika has hands-on experience, she will be covering this in greater depth. But these are effectively situations where a seller grants a buyer terms that are at least as favorable as those offered to other buyers. So 2 investigations thus far have been settled, and they looked at agency contracts of Apple and Amazon with various publishers, which related to the prices, the retail prices of ebooks. So Apple and Amazon would, in their contracts, according to these contracts, get at least as good a deal as their competitors. Now, in the field of verticals, we have seen a new impetus since the publication of the e-commerce report, or the outcome of the sector inquiry that the Commission conducted a few years ago. The results were published in 2017, and we see that there was 3 investigations stemming from this report. The first of these was into the retail price restrictions of various consumer electronics manufacturers, and actually that culminated in the imposition of fines in 2018. We will see that in just a moment. Then there was also an investigation into the geo-blocking practices between Valve, a game distribution platform, and various PC video game publishers. And what the Commission did in this case has done is look at geo-blocking as a way to prevent cross-border sales, so therefore restricting both passive and active sales. And this would be in breach not only of antitrust rules, but also the geo-blocking regulation. And the third investigation, so by the way, this geo-blocking investigation, there's been a statement of objections issued. I believe the game publishers have settled, and it's the game distribution platform is challenging the decision of the Commission. So that would probably lead to a Commission decision in the future, maybe an infringement decision, if it finds sufficient grounds to determine that this is actually indeed in breach of Article 101. The final investigation is that of price discrimination in agreements between a hotel chain, actually a Spanish hotel chain, Meliá, and various European tour operators. And again, this led to the imposition of a relatively modest fine of 6.7 million euros. Meliá actually decided to settle the case, so it accepted that it had breached the rules and it cooperated fully. So the Commission lowered the fine because of this cooperation. So the view was that Meliá's terms in its contracts with tour operators contained a clause according to which those contracts were valid only for reservations of customers who were residents in specified EU countries, meaning that this could, of course, threaten the single market, the view being that those customers should be able to get the best prices and should not have been restricted contractually by Meliá. So these are the outstanding changes or the outstanding situations that have been looked at after the e-commerce sector inquiry. Now, also another thing to bear in mind is that the European courts, on their part, have had the opportunity to provide some clarifications with regard to online sales bans, with the well-known cases Pierre Fabre and Coty, which I will also discuss in just a moment. And then we also have a Commission decision of early 19, where AB InBev, which is one of the biggest beer manufacturers, was fined 200 million for preventing parallel imports of beer from the Netherlands into Belgium. So anyway, these developments give us an idea of the priorities for reform, or at least for review, which is what the presentation will focus on from now on. And so what are really the big questions that need to be answered after these developments have taken place? So first of all, let's look at minimum resale price maintenance. So minimum resale price maintenance is normally considered to be anti-competitive by object. And if we look at the application of Article 101.1 of the Treaty on the Functioning of the European Union, and it's also a hardcore restriction in Article 4 of the current block exemption for vertical agreements, meaning that if a vertical agreement, a distribution agreement, for example, contains an obligation to observe a minimum price on the part of the resellers, then this would be anti-competitive by object. It's a hardcore restriction. The agreement would not benefit from the block exemption and is probably going to be considered to breach Article 101.1. So it's highly unlikely that the view of the Commission will change. So a manufacturer that wishes to prevent his or her resellers from engaging in price competition needs to understand that they will very likely be in breach of EU competition law provisions. Now, this is rather different from the position in the US, where all forms of resale price maintenance, minimum and maximum, are analyzed under the rule of reason. And in China, for example, this is different. We have seen some cases where the competition authorities have taken a harsh approach against minimum RPM. So some of the first fines, indeed, after the introduction of the law in 2008, related precisely to minimum RPM. So the issue is that from an economic perspective, and of course, I would very much like to hear Avantika's views here, it seems that there may, of course, be harmful effects, sure, but it is hard to argue that these restrictions are inherently harmful. So, for example, RPM can prevent free riding by retailers, and RPM sometimes allows compensating those that supply additional services, for example, and indeed might enhance competition between retailers in non-price services. These would be just some of the examples why a manufacturer might find it desirable to establish a minimum price at which the products can be resold. Now, we have seen that the Commission in 2018 imposed fines on electronics manufacturers So it imposed fines on 4 competitors for imposing RPM on their retailers. And this suggests not only that these restrictions remain harshly treated, but that the focus is that on the ones that might actually have horizontal effects. So here we see that since all the competitors, these 4 competitors, were all implementing minimum RPM measures or requirements, it could have been a way to facilitate some kind of horizontal collusion between them if all competing manufacturers are imposing similar retail prices on their buyers. Right, and I've included here in the next slide just to liven the debate about this. I borrowed this slide from Derek Ritzman, who did a presentation a few years ago at my faculty. And this is an actual advertising campaign encouraging customers to go to a nice brick and mortar store in a nice area in London to check out the electronics they wish to buy, to get all the information from that retailer who is incurring the costs of having a prime location and providing all the relevant expertise, and then to go and not buy from that retailer that has spent that time with this client, but to go online and make the purchase at a cheaper price. So this is in effect advertising free riding. And since minimum resale price maintenance is unlawful most of the time, and online sales, we will see, cannot really be banned in most cases, then there is little way to prevent this currently. Right, so linked to minimum resale price maintenance is the idea of most favored nation clauses, which there has been, as I mentioned earlier, some actions recently. It seems to suggest, these actions on the part of the Commission seem to suggest that anything that can lead to vertical price fixing is going to be seen as contrary to Article 101 TFEU by the European Commission. Now, please note that since these cases were settled, the European courts have not really had the opportunity to give their view. So this is still, we only know that there's been some investigations and that the companies agreed to remove the controversial clauses from their contracts. Now, the other aspect that is relevant for this reform, another aspect is the restrictions of online sales. I briefly mentioned that earlier. So we know, what do we know for the time being? We know that an absolute ban is unlawful, even for luxury products. And we see that in the case Pierre Fabre. And the cases, by the way, relate to selective distribution of luxury products, the main cases that we have. So Avantika will dwell on this matter later. But what the European courts have told us is that a manufacturer can legally restrict the sale of luxury products on third-party websites and platforms, such as Amazon on eBay, because this could harm the brand's image. So an absolute ban is not okay, but it is okay to ban third-party sales on websites such as Amazon and eBay. So the rationale goes back to the old case law on selective distribution, in particular the metro conditions and the indispensability of the restrictions imposed by the manufacturer. We will come back to this later on in this seminar. So finally, I think an aspect that we need to also discuss is absolute territorial protection. This is where perhaps the EU case law and mindset differs the most from other jurisdictions. The reason being that the EU competition rules are in a treaty that has as its main objective the creation of the single market. And this is present in this intention to, or this obsession, let's say, by the Commission and to a lesser extent the courts, to ensure that practices that might divide the market along national lines should be struck down. So with regard to absolute territorial protection, in addition to the clarifications provided in the guidelines, as I said earlier, as to what constitute active and passive sales, normally passive sales or restricting passive sales initiated by customers is not lawful. We have three cases. We've seen the geo-blocking case, that this statement of objections issued that describes these practices as passive sales, which can therefore, which should therefore be allowed. Then the decision against Meliá is a second case, where again we see that the Commission has emphasized that both passive and active sales were restricted, and more recently the fine against the largest beer manufacturer, AB InBev, for preventing parallel imports. However, please note that one peculiar thing about this case is that it has been brought not as a breach of Article 101 of the Treaty on the Functioning of the European Union, but as a breach of Article 102, so as an abuse of dominance. The market share, interestingly, the market share of the company was calculated to be around 40%, which is almost borderline a finding of dominance. As you know, probably from the guidance issued by the Commission, normally 40% is enough for a finding of dominance if there are other factors that suggest that dominance does indeed exist. But any lower would have been somewhat difficult to argue. We have had, some punctual findings of dominance, 30-something%, but that is very, very rare. And the abuse in the case was restricting the possibility for supermarkets and wholesalers to buy the specific beer at lower prices in the Netherlands and to import it into Belgium. So this has been considered an abuse of dominance. So what can we expect then from the reform in light of these developments? So let me be clear, I do believe that we will probably get a new block exemption and a new set of guidelines. So, of course, the possibility is on the table that we may no longer have a block exemption, but the most likely option is probably to continue the same system that we have now with some changes and particularly with some specifications. So a minimum RPM and the practices that we have discussed that might lead to vertical price fixing will probably remain harshly treated, probably anti-competitive by object, and the same goes for the threats to the single market and the measures that might grant absolute territorial protection by inter alia preventing parallel imports. Now, this does not necessarily mean that the approach will remain as rigid as it has been until now. Regardless of even what the Commission says, if the courts are given the opportunity to rule on these matters, we might get much needed clarifications. In particular, we know that the courts have insisted that object restrictions might be considered lawful if the undertakings can show that there is an objective justification for these. This should also apply, of course, to object restrictions in vertical agreements. There is no reason why this logic should not apply. And now the problem is that at the moment, we don't really know what constitutes objective justification. We don't have too much case law on this. So it would be helpful, for instance, if the guidelines might elaborate so that the companies know what they might be able to argue if they want to defend a practice that they feel is necessary and that they feel that they need to implement that is normally considered anti-competitive by object. We also know that there is case law demanding a case-by-case determination of whether a restriction of competition by object exists, rather than relying on categories, particularly since carte bancaire, as you know, from 2014. So a restriction of competition by object needs to be determined by looking at the content and the objectives of an agreement, of course, but also by looking at the legal and economic context, and that is a bit more demanding. And in particular, the Court of Justice in the carte bancaire case, we saw that it said, well, it's not very coherent to say that there are possible legitimate aims for implementing a restriction and then to say that it is inherently harmful. So that needs to be further elaborated on. So that's something that maybe the Commission could provide greater guidance as to how that object category is going to apply to these specific restrictions. The final consideration is whether Article 1013, i.e. the legal exception, could play a greater role in the future. Now, this is somewhat complicated because until now, object restrictions on hardcore restraints rarely ever have benefited from this exception. So it frequently doesn't really come up. The issue doesn't really come up in cases. Plus, meeting the cumulative conditions of Article 1013 is certainly complicated. So it would be great, again, if the Commission could provide some clarity as to whether or not it might be the kind of arguments that it will be considered, or that it might be willing to consider for the above restrictions as possible justifications for the above restrictions. So with this, I want to end because I know that there are a lot of questions, and hopefully some more might have come up. And I know also that I'm very keen to hear what Avantika has to say with a more practical economic perspective on these issues. So thank you very much.
Thank you, Sandra. You have been actually extremely succinct, but you will have more time to elaborate perhaps later on. Exactly. And now the floor is to Avantika, and you might want to share your slides. Thank you.
Yes, thanks. Thanks, Sandra. That was great. In half an hour, a comprehensive summary of all the things that has been going on. Let me. Right. Can you see my screen?
Yes.
Or rather my slides?
Yes.
Yeah. Okay, great. So yeah, what I thought I'll do is come at it definitely from an economic perspective, and as Sandra said, from a practical perspective of what we see in real cases, and how in some sense the guidelines are applied or not applied in cases. And before I go on, and I'll try to raise some questions for hopefully to pick up on the discussion later on. But before I do that, I just thought that I'll start by just reminding us all really about vertical restraints and what an economist's view is likely to be. And I say likely because, I mean, of course, I can't speak for all economists, but generally speaking, there is consensus that very few, if any, vertical agreements. Oops, for some reason, you can't see my screen. Can you see it?
No.
Yes, now we do.
Yes. Now yes.
Sorry, I was saying that from an economic perspective, there's hardly any vertical restraints which you would argue is a hardcore, falls in the hardcore category. And the reason is quite simple.
Could I ask you to put it in the presentation mode so that, because otherwise it's really very, very fine.
Yeah, sure.
Sorry.
Yeah. How about this?
Great, thank you.
And I won't go through all the details, but this is more of a reminder for us to have in our minds that there are vertical restraints generally are not obviously anti-competitive, and we know that there are anti-competitive effects, but there are also efficiencies and benefits of most of the vertical restraints that Sandra talked about. And a nice way to think about it is, now why is it? What's the crux of it? Why is it a vertical agreement not obviously anti-competitive? And I always like to think about the example of, let's say, a selective distribution system, which necessarily reduces the number of retailers a brand or a manufacturer uses to sell its product. Now, and a selection distribution system would therefore necessarily, almost like by definition really, reduces the number of retailers than if you didn't have an SDS. And therefore one can say, well, it reduces retail competition, and so it may increase retail prices. And if it does increase retail prices, then our economics would say it reduces the sale of that product, of that brand. So why would a manufacturer want to reduce the sale of its product? I mean, that's a natural question that follows through if you just go through the logic, is that yes, a manufacturer's incentive in SDS, what is it? Because it reduces the sale of a product if the prices are higher. And that then brings you to the question of, well, does it? Does it really decrease the sale of product? Or does it actually increase the quality of the retail service and therefore sales of the product? And is the manufacturer, does the manufacturer want an SDS to make sure that it's not all about price, but it's also about the quality of retail service, all of which then feed through to the sales of the product? So that's a nice way to think about it, because it starts from almost the rationale, the business rationale and the economic incentive of parties, manufacturers, retailers, to have vertical agreements and vertical restraints in the first place. And I mean, there are obviously lots of studies that have highlighted this from an economic perspective. If you want a summary, you can look at, we did a study in 2016 for the CMA. Together with the CMA, it involved a summary. It includes a summary of the literature of the pro and the anti-competitive effects, but it also had a kind of, we did around 30, 40 interviews with manufacturers, retailers, some platforms as well, in order to understand the rationale, the business rationale of using vertical restraints. And so it's quite a qualitative study, so it's kind of nice complement in some sense to the Commission's e-commerce inquiry. So I won't go into all the details about the anti and the pro-competitive benefits, but just to say that clearly it's not clear-cut at all why there should be a hardcore box. Now, of course, this is not just me saying it. This is just generally accepted point, accepted by the courts in Kuti, by authorities, e-commerce sector inquiry, and so on. And Sandra, you have already talked about this. That's Dixon's the advertisement of free riding, and that's obviously one of the highly mentioned rationales for having a vertical restraint. Now, one quick point on online. Now, where does digitalization on online lead us? Interestingly, online is obviously increasing the scope of inter and intra-brand competition, because you can have a lot of retail competition, a lot of online retailers or not. You can have a lot of transparency and visibility about different brands, but at the same time, it increases the risk of free riding. So it's actually in some sense the same thing that increases the efficiency benefits as well as the potential harm. So in some sense, it's two sides of the same coin. And how do you balance the two sides? And from an economic perspective, the general view is, look, if you have enough inter-brand competition, then you don't worry too much about the lower intra-brand competition, i.e. just between the retailers. So I just wanted to talk a little bit about where then this leads us, the fact that there's harm but benefits as well, when we think of the revision of the block exemption regulations and the guidelines. Now, let me tell you right at the beginning, and what my view is here at the outset, and I would, as an economist, I would struggle to see how the Commission can drastically change the block exemption regulations to, for example, to put things in the hardcore or not, take things out of the hardcore box. But I can see lots of possibilities for revisions to the guidelines and lots of scope for giving more it's not legal certainty, just more guidance around how should we think about these things. So just to take an example, MFNs. You might know that MFNs, there has been a lot of cases. Sandra mentioned the Commission cases, but there's a lot of cases at the NCA, so at the national level, in the hotels market in particular, but also insurance markets. And the two questions that arise are, look, wide MFNs and narrow MFNs. I don't know if everyone is familiar. Basically, wide MFNs mean that you get the best price. You as a, say, platform get the best price amongst all other channels. So you can say I'm the best price. And narrow is when you get the better price relative to, or the same price relative to the hotel's direct channel, but in Expedia or in other platforms, the hotel might offer lower prices. So the question is, are these, how should we think of these MFNs? Are they obviously anti-competitive? Are they likely to be by object cases? Are narrow MFNs and wide MFNs, is it the same? Now, the current case law and evidence base doesn't lead us, in my view, doesn't lead us to a definitive answer. As I said, there's mixed decisions at national levels. For example, in the hotels case, some countries, some authorities banned narrow MFNs, but some banned wide MFNs and not narrow MFNs. And there were also some reversals. Most recently, the Court of Dusseldorf reverted the Bundeskartellamt decision of banning narrow MFNs. So they said, no, narrow MFNs are okay. And free riding was mentioned as a specific reason. And then there is a lot of ex post assessments, which also gives us some mixed results. There was an ECN study done on hotels, which didn't quite find a clear impact of banning MFNs. The very fresh study that the Commission, the Commission didn't undertake it themselves, but they commissioned, found that the narrow MFNs in hotels actually did cause harm. So banning narrow MFNs did reduce hotel prices. And then you have other studies in the insurance market. Overall, the evidence base, and there's a lot of theory, but the actual evidence base around the impact on MFNs doesn't really give us enough. It doesn't clearly show that, okay, fine, you know what, the wide MFNs, narrow MFNs, all of these are clearly harmful. Here's the kind of price impact we are seeing. And in fact, from an economic perspective, it makes sense. This evidence, a lot of the evidence is in hotels, but also some in insurance, can't really be generalized because we know that the market features are quite key. So you can easily, for example, compare hotels and insurance market and come up with very different answers. And this is one of the debates. There's a case in the UK ongoing now in insurance and MFNs. And it is also recognized actually in the recent evaluation study, that yes, in the hotels market we find an impact or harm from narrow MFNs, but it's not clear that this can be carried over to other markets. So, in all, I would say, well, where does this leave us in terms of VBR and the vertical guidelines? It just, again, I think stresses and underlines the point that you can't really ban wide MFNs or narrow MFNs, just put it in a box because it's so context dependent. The other thing I just quickly wanted to, that example I wanted to touch on, and I think this is something that the Commission can spend a little bit more time in the guidelines possibly, is selective distribution system. Again, as Sandra said, there has been COTI and there has been other cases. COTI was about ban of reselling the product, ban on the authorized reseller through sell to marketplace, so marketplace ban. There has been a case Ping in the UK, which is ban on the online sales of the authorized retailer. The one issue, and again, Sandra, you touched on it, is the metro criteria, about the selection criteria itself of the SDS. And to my knowledge, there hasn't been a case where, at least, where there's a lot in the public domain, or not a case that has progressed much. There was a case recently in the UK, L'Oreal versus Beauty Bay, which was precisely about this. Was the brick and mortar requirement in the SDS, is that an infringement of 101 or not? Did it serve a legitimate objective, or did it go beyond what is necessary? And what is very interesting, the factors that are quite relevant in this debate about the criteria itself is, yes, again, it's free riding, as we talked about, but interestingly, free riding, we use the word free riding in a broad sense, but actually there's a little bit more to it than just that one word, because the question is, free riding which way? Is it that I'm going to the brick and mortar, searching around, buying online, or am I searching online and going to brick and mortar and buying? This is known as showrooming versus web rooming. Or even if I look at only online channel, am I searching one website, one price comparison website, and going and buying somewhere else? So that's also free riding in some sense. So again, these are not easy questions. These are all very context dependent. And I really struggle to see how the block exemption regulations can tackle it, how you can meaningfully change something there. To my mind, these are all things for vertical guidelines. And yes, I completely agree that it needs a whole big section on, well, not even a big section, it has to be scattered with all these things about online that has come up in the last 10 years or more. And then definitely is a scope for actually, like case studies, clear guidance and clear examples of how to deal with these kind of cases in the new world that we live in. So I'll stop there, conscious of time. I don't know, if it's a good moment to, any comments, Sandra, from you, or good moment to lead on to the discussion.
If Sandra agrees, it might be perhaps appropriate to give her the floor if she has any comment to make on your presentation.
Sure. I mean, we can go ahead and as the questions come up, we can comment on each other's talks. So that's fine. Okay, so we have a few kind of prepared, questions which were already circulated, and I would then ask Ermelinda to go first, because I know she has a couple.
Yes, can you see me, hear me?
Yes.
Yeah, excellent. Thank you. That thanks so much. That both presentations were super interesting. Just I'd be grateful for your views, both Marta or Avantika, about a point where when Sandra was talking about the EBI InBev fine by the European Commission. I mean, this mind-blowing 200 million euros fine. And we've recently read in public sources that Mondelez is also subject to an investigation for similar practices. And you were really pointing out to the fact that the 40% threshold, it's a fairly relatively low threshold for dominance. And actually, I was wondering, do you think the case would be much more difficult to run under Article 101? I mean, after all, it's an agreement between undertakings. So I'd be grateful for your thoughts on that, if that makes sense.
Can I? Okay,
Yeah,
so
yes.
I wanted to say hi. Thanks so much for your question, Melinda. So the problem, I think, the reason why it has been brought under Article 102 is because you might remember the Bayer case. And the problem there was that, if you remember the situation, we had Spanish and French wholesalers of drugs who exploited the price differences that happened in the EU in pharma products, and they exported quantities of the drug. They bought the drug not to sell it in Spain, but to sell it in the UK, where the price was higher than in Spain. And as a result, what happened was that the sales made by Bayer's UK subsidiary dropped significantly, and Bayer responded by limiting the quantities it was selling to the Spanish and French wholesalers. Now, again, the European Commission back then brought the case on the basis of 101, limitation of parallel imports. But when the case went to court, it lost on the basis that there was no agreement. So it lost on the basis that actually this restriction of the amount of drugs sold to the Spanish wholesalers was not an agreement. In fact, the Spanish and French wholesalers did not want that restriction, right? And the fact that they kept buying from Bayer did not mean that they had come into that they had reached an agreement, and therefore Article 101 could not be applied. So my guess is, if since they saw an opportunity for a finding of dominance, which of course, I mean, at the moment all we have is the press release. We don't have yet the full text of the decision. It's hard to know exactly how they argued for this dominance. They thought it would be maybe safer to play the 102 card. So yeah, I think that's the risk of going ahead with Article 101.
If I can add something, I mean, again, not about AB InBev in specifically, but just a small nugget, interesting nugget. In the UK, for example, I mentioned the case, ongoing MFN case in home insurance. That is against Compare the Market, which is one of the, it's not, I don't know, it's a tricky with shares of price comparison websites, but it's not too large. It's less than 50%. It's one of the 3 big price comparison websites. And the case is about the MFNs, which is, there's a clear agreement there, right? But the CMA has brought the case as a 102. Even when they could have done 101. And that's quite interesting. I don't know, I mean, what you make out of it. But clearly, I don't, maybe they thought that it's easy to establish dominance, but, on the face of the market shares and things like that, it's not like CTM is the only 90% share. So it's an interesting one. I don't know the answer.
What really makes me think is that if the Commission is convinced that territorial restrictions are the absolute evil, it's a way you're fighting only half a battle if you're fighting it only if you establish dominance. My sense is that they should have a bit more courage and do it under 101. But if it's so important, just go for 101. But that's what's very interesting. Thanks for your thoughts.
Melinda, didn't you have another question on 101.3? Do you want to ask that one too?
I didn't want to monopolize the discussion, but by all means, actually, I was being shy away. But I'm a fan of 101.3 in the sense that I think it should be used more. But both companies and us advisors are quite careful in getting into this territory. Normally you want to just say, well, there's no 101 restriction there. And when you're already in 101.3, you get a bit more nervous and more concerned, also, obvious for the reasons related to the fact that you need to keep you just need to continuously monitor that you satisfy the criteria for 1013, and obviously you can't really have feedback from the authorities other than in exceptional circumstances. So all of this to say, when you said, more room for 1013, I was a bit intrigued to see whether how you feel that things can change, and the practical relevance of 1013, really the practical one can be improved, because I think it's a very powerful, useful tool.
Yeah, so I agree with you that this is a problem, because in theory, this is the difference. We always say, well, object restrictions is not the same as per se, because an object restriction, you can have something that is anti-competitive by object under Article 101.1, but then you could apply potentially Article 101.3, or, it could have an objective justification. So there's always an escape that perhaps there might be a way for the clause to be legal, right? And whereas under the per se illegality in the US, then of course if something is per se illegal, you're in breach of the Sherman Act. Now, one of the reasons behind the 2010 reform, so i.e. the rules that we have now, was one, to limit the scope of the application of the prohibition of Article 101.1 and how it applied to verticals, and also to use 101.3 to assess the potential benefits and efficiency of practices falling within the scope of the prohibition. Now, in practice, since these restrictions, especially the ones that we have discussed, are considered anti-competitive by object, what we are finding is that, and there are also hardcore restrictions in the block exemption, there is a presumption that Article 101.3 does not apply to them. And that is this is what we're finding in practice. So also object restrictions, we also know that they do not benefit from the de minimis rule already since the Expedia case and the revised de minimis notice. So I agree that this possibility this distinction between per se illegality and object restrictions is in practice at the moment not so different, because of the lack of use and lack of resort to Article 101.3. Now, maybe this is a problem with the design of the provision itself, or maybe it just requires more nuanced applications. But very few cases arise where the parties rely on the application of Article 101.3 because they know that they have very few chances of success. So what we find is normally that the parties altogether try to avoid the hardcore restrictions. That's what happens very often. So there haven't been many opportunities to develop a detailed framework for the application of this provision, is what I find. I don't know if Avantika has any views on this.
Yeah, I mean, I think that's a, it's a big question, and my view is that this division of 101.1 and 101.3 doesn't really serve us well in terms of a holistic assessment of an agreement. And we do see from a practical perspective, sometimes we kind of try to talk about the efficiencies, but under 101.1, it's not, obviously it's not easy to put it under 101.1, but you can, in certain circumstances, when you're assessing whether there is a harm, you actually take into account which one might say, no, that's efficiency. And sometimes you do get that pushback saying, no, that's not for now, that's for later. This is not part of 101.1, from a practical perspective. But one example I do want to cite, which is the Beauty Bay versus L'Oreal case that I mentioned, which was about the brick and mortar criteria of the SDS of L'Oreal. I was involved in that as for one of the parties as the expert. And because there, the focus, one of the big focus area was the metro criteria. Is it a legitimate criteria? Does it go beyond what is necessary? And that falls under 101.1. And you know better than me, the intricacies of that. But there, from an economic perspective, the analysis we did there was a lot of analysis around efficiencies, free riding. Is there showrooming? Is there web rooming? Which one is stronger? And in some sense, as an economist, that's the exact same analysis I would do under 101(3). It's just, you know, in that specific context, it made sense because you needed to tackle that question even for, you know, under 111 basically for exemption. So that was you know, that was quite interesting, you know, and it's true, you don't get to do that very often. So it was actually super interesting to actually tackle that question head on, because it was so intricately mixed with whether it's an legitimate criteria.
Yeah, no, that's very interesting. And now that while you were talking about that, going back to the 101, 102, it's funny enough that on the booking case, you know, considering whether to go under 101 and 102 on the MFN, after all, they went under 101, even if the hotels hated those clauses. So yeah, interesting. Thank you so much.
Thank you.
So we thank you. We do have at least 2 more questions and possibly more. One is from Pietro Merlino. Pietro, please go on.
Thank you, Cristoforo. Well, mine, more than a question, is probably a consideration on which I'd like to have the view of both Sandra and Avantika. My feeling is that, yes, sure, in the new guidelines, the Commission will probably say something more about online than it did in the previous guidelines, building on the various cases that Sandra and Avantika have discussed before. But I really think there will not be major revelations. We will not read that guidelines and have a clear view on all the very complicated issues that have been raised today. Because my feeling is that this will be a matter of decisional practice. Competition authority deciding more cases than they've done so far, going on appeal before the national courts, the Court of Justice, and that would be the only way we will get more clarity on that. Also, because if you look at it somewhat closely, all the instruments are there because, yes, okay, for example, let's take RPM. RPM is certainly our core under the regulation, but then legally speaking, the only consequence is that you don't benefit from the block exemption of the regulation. There is no presumption that this will never be possible to implement. Once you go out there, then yeah, it may be by object, but then we know from Carbon Care and others that even by object, to qualify something by object, you need to look at the specific context of the specific case. And then you still have, as some of you said, Article 101(3). And I think everybody, nobody almost reminds that the current guidelines, the 2010 guidelines, with respect to RPM, they provide, they explicitly mention the idea that an RPM may be justified under 101(3), precisely because it allows retailers to provide pre-sale services, which customers may benefit from, and the RPM may somewhat eliminate free riding problems, which will have detrimental effect on those pre-sales and non-price services. This is clearly said in paragraph 2, I think 225 of the guidelines. But again, I think that we will also need some more courage from companies to try to somewhat challenge and tackle the old EU orthodoxy on vertical agreements. And that to me will be the main way to achieve more clarity and maybe to get to more satisfactory balance in the application of competition rules to vertical agreements. Thank you.
Avantika, do you want to start? Or? Avantika.
Have mute on.
Right. I was saying that I actually agree with you. Maybe I'm a bit more hopeful that there will be a bit more on online and you know, but yes, you know, in some sense, I don't think it'll solve the complex issues, and those have to be solved through cases appeals and court views. One thing that I don't know what your last comment that well, companies have to be just bold and just go for it and to make cases. One of the things that and again, and this is something I'm sure you have faced when you talk to your clients, is what we found when we did the study for the CMA, because we were surveying people. We were we were kind of interviewing people, right? And it was very clear that what we were hearing is that, look, we don't want to vertically integrate, especially we heard this from manufacturers, but we have a principal agent problem here. We want to incentivize retailer services and all that, but we can't do RPM. We can't do like SDS, selective distribution criteria, that's being scrutinized. We can't do dual pricing. And so there are so much, agency models are also under scrutiny. Is it a true agent or not? So with all the scrutiny, there was a tendency to think, oh, actually, there's a move towards, and not in every sector, but in some sectors, there's a move towards more vertical integration, in the sense that manufacturers say, you know what, I'll do it myself, because this is all very uncertain, and this, like, I'm not sure what can or cannot do. So yeah, I don't know, maybe that's just a few sectors, and some others will be more bold and make those cases.
Yeah, I mean, I think what normally happens is that what might happen is that the Commission will reflect in the guidelines on the things that have been already discussed in some of the recent case law. Like you say, that normally that's the order normally of the way that things tend to happen. So yeah, I mean, I agree with you that it will be more a question maybe of codifying the more recent developments. I think that what it does need to do, I think that's what I tried to say in my presentation at the end, it needs to bring together the vertical restraints, let's say, the principles that apply here, to the principles that it has been applying, or that the courts have developed, let's say, in other cases, in other areas of competition law, including this, the possibility of objective justification, and the how to determine what constitutes an object restriction, and the thoroughness that was required in the analysis of this should also be required when it comes to vertical agreements. So I think that hopefully I would like to see that reflected in the guidelines, to bring the area in line with the how competition law is now working, or how the court has wanted it to work. These big questions about object and effect, etc.
Thank you. So we have, following first serve order, we have Ricardo Panizzi with another question.
Yeah, thank you. It's again, it's a comment more than a question, on which I would like to have your views, and it's somehow linked to what I've just heard and that I do share, which is that we still need clarity, that there are still gray areas, that entering into the notion of objective justification might be extremely complex and difficult to succeed on. That Article 1013 is rarely applied. So taking all this into account, Peter was talking about courage. My concern here is also a very practical concern, and I was wondering whether you have any thought on this, which is the level of the fines. We've just seen fines increasing a lot. We've just seen 200 million fines, which is quite surprisingly, it's a 102 case, but and that is not surprising then, but the behaviors were behavior that could have been addressed also under 101 on a vertical point of view. So it's there. And we've also seen that for the horizontal agreements, we do have some indication by the Commission on the potential level of fines. We already know that the 15% thresholds will be hit. There is the leniency, And we've seen that also in vertical agreements in the Pioneer case, the Commission did not use the leniency program, but it did do something very close to it. So I was wondering, isn't it time to do something also on the clarity, on the potential level of the fines for vertical restraints? Because fines are increasing, we know that, but it's very hard to predict if you do something wrong, what level of fines you might attract. So I'm asking myself and asking to you as well, of course, whether there is some clarity that can be brought on this and how. I mean, indicating a threshold on the value of sales, indicating that certain behavior there are by object, but again, after carbon care, it's again very complex, and I wouldn't do that. Attract a certain level of, I mean, it's quite complex because you need, in order to have the courage that Pedro was mentioning, to have at least an idea of what you're risking. So that is my, let's call it, question.
So I don't know if I can go first or you can go first. Avantika, I don't mind.
Sandra.
So, I mean, I think, I'm also actually studying the level of fines. I mean, we have, of course, the parameters that we know from the guidance issued by the Commission, the turnover thresholds, etc. Well, I have seen, let's say, well, there is two tendencies. One is that, like you say, the fines are increasing. So there is a tendency of maybe trying to exploit those limits that the Commission has to impose fines to their maximum capacity, or at least to try to increase the punishment potential of those fines. Perhaps they were, the other argument is where maybe they were too low originally. Well, that's something that is a matter for debate. What I do find now is that between, like you say, leniency and then the settlement notice, what I'm finding is that we see now that there are a lot of cases, including this fine on Meliá, right, where you see, well, there is at least a lot of encouragement, let's say. I think let's say the discretion that the Commission has to impose the fines allows it also to pressure the companies to cooperate, because if they cooperate, then of course they get a reduction, and to settle indeed, because of course that makes it easier for the Commission to win a case, and the companies know that they will see a reduction in the fine imposed, and they are likely also to be considered to have cooperated, like in the Meliá case, and then of course that will also act as a mitigating factor in calculating the overall level of fines. So of course we do have these, let's say, factors which allow us to predict to a certain extent, or to at least they give us, a margin on which the fine is going to be imposed. But yes, I agree with you that the other view on this is, well, if the law, or if this punishment becomes too predictable, then perhaps the deterrent effect is no longer there. So companies need to know that actually when they're doing something illegal, they might be punished harsher than they originally thought they would be punished. So of course that would be maybe the counter argument to what you're saying. So just again, as a comment more than a solution. I don't know if Avantika would like to share anything.
Yeah, I think that's an interesting comment that you made, the incentive effects of clarity on fines, both on deterrence but also on settlement outcomes. And again, we know that the companies do have some incentive to settle and have a very narrow or hardly anything from the Commission because of any potential follow-on damages exposure. But I have nothing to add to that. But one thing I would say is, from our perspective, we do find sometimes ourselves involved in quite involved kind of effects analysis, even in by-object cases, not because we think we can move the by-object, move the case out of a by-object box, but because of just that optics of showing that, look, if we see that there's really no clear effects, possibly you find absolutely no harm, then it kind of sends that signal of discouragement of huge fines. And frankly speaking, sometimes you are successful, sometimes you're not, but it really depends on the appetite for trying on that front.
Thank you. But then my additional link question was the 200 million fine for beer, would it have been significantly lower in case they would have acted under the 101 for a vertical restriction or not, in your view?
It's really hard to predict that, particularly because at the moment, as I said, we haven't really read the whole decision, and I always like to know on which grounds they came to that final amount, right? So it's not at the moment. It's not clear. At least I don't have the information to know how they came to this amount, or whether it would be any different. I don't know.
Thank you.
Thank you.
So we thank you. We have a further question from Lorenzo Pace.
Yes, well, thank you, Sandra and Avantika, for your impressive presentations. My question is more on the legislative policy side. And that is, and I would like to have an answer from both of you, from the legal and from the economic point of view. Do we need block exemption regulation? I mean, would you abolish them? I'm sure that from the legal side, probably you would like to keep it. Maybe from the economic side, you would like to have more economics in it. But since in the US they don't need any kind, they don't need any kind of regulation this way. And on the other side, if you see the motor vehicle block exemption regulation, it looks to me more an industrial policy regulation than a competition policy regulation. Well, what's your position on that?
I think they were both. I mean, the motor vehicle regulation was quite different, much more specific, and this being an umbrella block exemption with quite broad, let's say, general criteria. Could we remove it? I mean, I think that again, if you go back to my presentation, block exemption regulations had a very clear purpose under the previous system of enforcement, where all the agreements had to be notified to the Commission, including all these agreements that were mainly most vertical restrictions, or most vertical agreements at least, were not harmful to competition and would be normally exempted by the Commission. So it was to avoid that requirement and the Commission having to look at something that really had, on very few occasions, anti-competitive effects. I think that the companies like the legal certainty of having a document that they can look at, a regulation which is legally binding on all the member states, and that they know that if they meet the requirements of that block exemption, that their agreement is going to be perfectly lawful. And actually, what is really interesting, when I wrote my PhD on this, and I advocated maybe that it's time for the removal of the block exemptions. And now I'm in Hong Kong, and here they're actually adopting block exemptions because actually, again, they like that idea that for certain blocks of agreements, you give the companies something to look at, something legally binding that they can actually draft their agreements to ensure that they meet those requirements. So yeah, there are.
Sorry, Sandra, for interrupting you. There in Hong Kong, who's writing the block exemption regulation? The Parliament, or I don't know, is the Competition
Commission will draft.
Okay.
Yeah,
okay.
Has the power to draft them. Yes. Yeah. So just as a.
Yeah, I mean, I think, Lorenzo, I mean, even though some may say, yeah, as an economist, that'll increase my workload. I would say that actually I do see some benefit of keeping the block exemption, because, again, when we do, for example, risk assessments, not an investigation, just a compliance in the process of compliance programs, risk assessments. Most of the time, these are genuinely borderline cases, or above the 30% threshold, but kind of this 30, 35, 40 range, right? And frankly, it is quite clear when you're a really small company. It makes sense that you have a legal certainty, you know what you can or cannot do. Now, sometimes you do get into the debates of how to calculate that 30% or those thresholds, and whether that's reliable enough. Is that how the commission or an authority would look at it? But for most cases, I would say that you can actually take a view, and that is actually quite helpful. So as an economist, I would say it is helpful.
So also, Sandra, just to add on that, but actually thinking of it, also the US, somehow they have this, they don't have regulation, but they have guidance. So they need some, would you make this comparison? Do the US have this kind of?
I think the problem with the U.S. system is it's so different, right? It was so it developed on a case-by-case basis from the first moment. Whereas we have here in Europe, we had the Commission, especially in the early years, almost having the monopoly of the application, especially of 101(3). So it's a very different evolution, and also we have to think that now the vertical restraints that we are discussing have been under the rule of reason for quite a long time. I also should point out that actually I was reading recently a study by Douglas Ginsburg and another by Danny Sokol, I believe it was, showing that actually now in the US it has become really difficult to win a case relating to vertical restraints. So I think defendants win more than 90% of cases. So do we want to go that way? I mean, it's very difficult to see. So it seems that in the US, the rule of reason has almost equated per se legality. So I guess that it is a very different way of addressing these restrictions. A different principle that is applied when analyzing these restrictions. So it's very difficult to make the comparison between the two systems.
But still, they have a vertical restraints guidelines.
They have guidelines, yes, but yeah.
Okay. Thank you.
So I might have a question now then, not a particularly original one, but it's on this ban of internet platform sales. And honestly, I'm wondering whether it really makes sense what the Court of Justice is saying. I mean, having heard you, Sandra, saying that it's not very clear anyway, which is in a world where people are becoming more and more accustomed to marketplaces, and where marketplaces assure us that they can actually make it a pretty exclusive experience to buy in a marketplace where you have, the room for Prada and the room for Hermes, and a situation where the free riding, in my view, might be limited because, once I am set to go and buy a Jane Birkin bag, is it really a question of me receiving a particular service at the store in a very exclusive part of town? So I'm not really sure that this all makes a lot of sense, if not for trying to keep prices high. But in general, I would say, would you, in a situation which is pretty confusing right now and in a very critical area, would you have any suggestion as to what criteria might be dictated in this area in order for us to be able to distinguish what is legal and what is not?
I mean, I think that Avantika had a very good point about looking at the original case law on things like selective distribution. Even these issues were decided long before the internet existed, or at least that we began using it for the transactions that we use it nowadays. And these principles, I think they are general enough that they can be applied, and they are being applied often to online situations. You are absolutely right that sometimes, if we really are focusing on from an efficiency perspective, why would I, maybe if I'm a knowledgeable consumer and I've already decided that I'm going to buy this handbag, why would I want to pay for the extra service that I don't need because I've already done my research, and we are finding now very knowledgeable consumers that are, that become aware of the goods without the need for the investment in that. So of course, this is, that's exactly what we're saying. This is a complex issue. And yeah, I don't know. I mean, I don't know if, I think Avantika has more an idea of the cases that are happening and some of the criteria that might be helpful in this sense.
Yeah, I mean, I don't know whether there's many. The one that I mentioned actually settled, unfortunately. So there's not much hope of getting, more on that, the L'Oreal versus Beauty Bay one. But it's actually a good point that, what we saw in that case, and generally, if you look at the latest study for the Commission, that also has a study on free riding, and there you see that actually there are many people who would actually not go to the online at all. They'll search online, sorry, offline. They search online, they buy online, or they search online and they buy offline, and vice versa. So actually there's a mesh of things going on. So it's not very clear. Koti obviously talked about, the aura of luxury and, in the store, but, and maybe perfumes is a different matter, but and it will be kind of dependent on the product we are talking about. But for many products, including cosmetics these days, there's a lot of investment that's going on online, and in terms of even brands do the investments for the online offering. And it's not very clear which way the free riding goes, or even if there is free riding. And you see that also in the study, there's a lot of papers on that, but you also see that in the EC study, that actually the directions are pretty balanced. It's not very clear. So, but I would say that it's hard to kind of think about principles. What we have currently, still, I would agree with Sandra, still is fine. What would need to happen is, it has to be a case-by-case assessment. And yes, whatever, the Court of Justice said may be applicable in some cases, but may not be if the product is different, the product characteristic is different, like the customer demographics is different. That's very important, right? So if it's a young customer base who are, totally comfortable trying out their makeup online, then it's a totally different story.
Well, this would bring us back to this idea of case-by-case case law, which, however, has been criticized as far as the US are concerned.
Well, not so much criticized, it just highlighting the different evolution, right? It's just a very different system, yeah.
All right, so we are basically come to the conclusion with an incredibly precise calculation of time. Is there any participant who would want to raise his or her hand and ask a question now? Apparently not. Would you, Sandra, or would you, Avantika, wish to say anything before we close our discussion?
Just that again, grateful for the invitation, and I'm actually very looking forward to seeing what is going to happen in the months to come, because I think we can expect at least greater clarity on the reform and what we will get in the end in this new block exemption and new guidelines.
Yeah, no, same here. It was great to join the discussion. It's a really good forum to have interaction and debate. So thanks for that. And yeah, we'll see what happens.
Thank you. Well, sorry.
Sorry, I said I'm hopeful, but we'll see.
I have to say that I asked Sandra to start by not assuming that everybody on this group would know everything about all the subtleties of vertical restraint. So I think it has been quite astounding how you have been able, in 1.5 hours to go from, elementary school to postdoc of vertical restraints, which I think at least in our country is extremely rare. So I'm extremely grateful to both of you. With your permission, we will post your slides, and we will also post the registration of this meeting online. But if for any reason you would not want this, or you would want to replace your slides, you just drop me a line. And for anything else, we are extremely grateful, and we hope to have you soon again participate in these discussions.
Thank you.
Oh, thanks
Thank you very much to everybody.
Thank you.
Thank
Bye.
you.
Bye now.
Bye.
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 Bye bye.
Bye bye.